Karen Reed's retrial is supposed to take upwards to 6 weeks to complete. Now, it may even take longer than that. So you may be thinking that really the first few days of trial are really not that important. I mean, come on, how memorable does a witness have to be, or does evidence have to be, that the jury's going to be thinking about it 6 weeks later? Now, of course, they have notepads, they can be taking notes, and certainly in closing arguments are going to remind them about certain pieces of evidence and certain testimony. But you may think that really the substance of each individual witnesses and how long it takes to bring out certain points, that's not going to be so memorable. And that may be true. But there's a certain part about the beginning of the case, which is the opening statements, which I think is so important, and it's critical. It's really critical to put the appropriate time and attention to developing your opening statement. And which is why we're going to be talking a little bit today about the opening statements, and specifically what I think is a big mistake that Hank Brennan made when he was opening this case. Okay, now part of the opening statements is that you want the jury to think about the evidence in a certain way. You want them to think about evidence in your way. When you're the prosecutor, you want the jurors to think about the evidence as a prosecutor. You want them to think about it how it incriminates the person. And when you're the defense, you want them to look at this evidence and this testimony with with problems in their investigation and things like that. So it's so important during opening statements, more than trying to get the jury to remember and convince them with your arguments why you're right or wrong, but it's really more of a time that you want to frame the issue. You want to plant seeds about how the jury should take in this evidence, how the jury should take in these exhibits, how the jury should take in this testimony that they're going to hear. That's what you're trying to do. You're trying to frame the issues and get into their subconscious mind so that when the evidence is presented, when the testimony is given, they're able to subconsciously think about it the way that you want them to think about it, which brings me to my first most important point of an opening statement. One of the most, if not the most, important parts of opening statements is to figure out all of the weaknesses in your case. You've got to figure that out, and you've got to address it in your opening statements. You have to do it. If you don't do it, then we're going to see what happened in this case play out in all your cases, which is not what you want. Okay, during opening statements is usually not a time that you lose your case, but it's possible that in this case, in the Karen Reed case, it is possible that the jury already is so influenced by the opening statements, they don't even realize how subconsciously they're influenced. I'm going to explain to you why each individual point. Now, coming back to the original part is that you have to figure out the weaknesses in your case, and you have to anticipate what the other side is going to argue, and you have to dispel it. You have to tell the jury, especially when you go first. When you go first, one of your main jobs, if not the most important part of your job, is to figure out what the other side is going to say. You say it first, you frame it, you spin it to the jury how you want the jury to hear it, and then let the other side try to correct their original understanding in the way that you explained it already yourself. So that's what is so important about opening statements, and it's something that I stress to all of the lawyers when they're asking me about doing trials or opening statements. This is one of the most important parts. It's not just presenting your case. Of course, you have to do that too, but it's probably more important to talk about the weaknesses in your case and to frame it in the right way to the jury. Now, that was not done by Hank Brennan in this case, and that is why it allowed Alan Jackson. And when you leave an attorney like Alan Jackson and you don't talk about the weaknesses in your case, he is going to destroy it. He's going to destroy you on his opening statement. And that's exactly what he did. So what happened here during opening statements? Okay. So there's a few big problems with the prosecution's case. Number one is Michael Proctor. Okay. Michael Proctor is a real problem for the prosecution's case. They're going to hear about these text messages. They're going to hear that he was fired, that he was suspended without pay, and then he was fired by the Massachusetts State Police. You're going to hear about these things. So as a prosecution, what should you do with that? You know that this is going to come into your case and it's really not going to look good for you. What should you do? Well, the answer is that you have to talk about it yourself to the jury. You've got to figure out a way to spin it in the right way that's going to still allow the jury to come to a conviction. That's what you need to do if you're a prosecutor. You cannot ignore it. You can't ignore it. You have to talk about it. And that's something that Brennan did not do. And it's something that you need to do. So let me give you an example. Let me explain to you how, if I was a prosecutor, what I would do about Proctor. Something to the effect of the following. And I didn't really spend too much time on this, but this would be something to the effect of how I would deal with when I have a detective, a leading detective in this case, like Michael Proctor. Okay, ladies and gentlemen, the lead detective in this case is a fellow named Michael Proctor. Michael Proctor no longer works for the Massachusetts State Police. He was fired. The reason why he was fired is because he wrote certain text messages and he had the appearance of bias when he was performing certain actions on this case. Now, that's a fact that we don't love. I don't love that fact in my case, and I wish I had a lead detective that didn't do that. But, ladies and gentlemen, that is a red herring because the facts and the science and the data in this case is so strong that Karen Read committed this crime that it doesn't really make a difference what Michael Proctor texted his high school buddies. You're right. He should have never texted his high school buddies. He should have never spoke about Karen Read in the way that he did. And you're going to hear about a lot of that stuff. And it's pretty disgusting. I got to tell you myself, I don't like it. I think it's disgusting. I think it's deplorable. And he should have never done it. And I think it's right that he got fired. He should have got fired. But you know what? It doesn't change the facts of this case. It doesn't change the evidence of this case. And you're going to see so much evidence in this case, so much science data, so much forensic data that is going to be impossible to ignore. So regardless of whether Michael Proctor got his hands on this case and whether he was a lead investigator and wrote some inappropriate text messages, the evidence is going to be so strong against Karen Read that you're going to see that the only appropriate verdict here is guilty. Okay, that would be one way in how to deal with Michael Proctor. You got to do something like that. You have to do something like that. And if you don't, and you just ignore it, then Alan Jackson's going to get up there and he's going to say, do you know why the prosecution did not talk about Michael Proctor, the lead investigator in this case? You know why they didn't do that? They didn't do that because they want to distance themselves as much as they can from Michael Proctor because he's such a cancer. He's such a cancer in this case, and he's going to completely destroy any sort of credibility in the prosecution's case. And then he's going to capitalize on that. It's exactly what he did. That's exactly what Alan Jackson did. Number two, if you're the prosecutor, you got to talk about the Google search. How can you leave that to the defense? How can you leave Alan Jackson to say that there was a Google search at 2:27 in the morning? How long to die in the cold? How can you do that without giving the jury an explanation that you're going to have experts who are going to talk about that Google search and are going to say that really that Google search happened at 6 o'clock in the morning, so that you would say something to the following: ladies and gentlemen, there is a certain Google search that is going to be the subject of your attention in this case. And it's a very important Google search. It's not something that we're shying away from. We're happy to show it to you. We're going to show it to you. It's a Google search that was done at 6 o'clock in the morning. Now, Celebrate is a very reliable software. In fact, you're going to be seeing a lot of data from Celebrate. And it's important for you to take that into consideration. But Celebrate's not perfect. Every single software has some glitches. And there's a glitch in the Celebrate software as well. And one of the glitches were, in this specific case, that somehow this Google search registered for 2:27 in the morning when really it was a 6 o'clock in the morning Google search. So you're going to see all that from our experts. Everything's going to be completely crystal clear to you. But I don't want you to walk away with the wrong impression that there was some sort of Google search that we don't care, that we have any problem with. We don't. There's a Google search. We're going to explain everything. And there's a certain glitch in the Celebrate software, which they fixed already. They already fixed it. You're going to hear all about these glitches. You're going to hear all about the problems. And there's going to be no doubt in your mind that this Google search was done at 6 o'clock in the morning. Okay. That's what you have to do when you're the prosecution. You cannot ignore it. And if you ignore it, Alan Jackson's just going to get up there and say there was a Google search at 2:27 in the morning. Finish, period. And the jury doesn't know anything more. So what the jury is walking away with is the impression, number one, the prosecution is not honest because they're not telling you the full story. And then from there on in, the jurors already could be corrupted by Alan Jackson to be thinking that I can't trust Hank Brennan because I know that he's not telling me the full story. That's what they're going to think. And number two, they're going to be thinking that that's it. It's 2:27 in the morning. They're always going to be thinking in the back of their mind that when am I going to hear about that 2:27 search? How are they ever going to get around that? No matter what evidence I see right now on that Hank Brennan's putting up, I always have that in the back of my mind. So it's just a tremendous problem. Now, also, there was another problem with Hank Brennan's opening statement, and that was that his timeline was off. Now, some people have said that he misspoke. He said 12:34. He really meant 12:24. Well, the timeline is very important in this case. You can't blunder and mistake in the timeline. That's like the most critical part of your case. You have to say when he died. And if it's all comes to minutes and seconds, and you're citing the exact minute and seconds, and then you mess up on the minutes. And I had to listen to it a few times to make sure I had the timeline right, and then nothing added up. 7 minutes from 12:23 is 12:30. And then he said the incident happened at 12:32. And then they're at the flagpole at 12:34. Well, maybe he meant 12:24. How is the jury supposed to figure this all out? And this is opening statement, so they're already confused about your opening statement. So you can't mess up the timeline. And final thing, I think, is that another thing that you have to do as a prosecution, another thing that you have to do as any type of lawyer, anytime you're presenting to the jury, is talk about the burden of proof. You have to talk about the burden of proof when you're the prosecutor or when you're the defense attorney. Obviously, when you're the defense attorney, you're going to be talking about the burden of proof. You're going to be saying how there's just this tremendous burden on the prosecution, an insurmountable burden on the prosecution of reasonable doubt. They have to prove every element of their case beyond a reasonable doubt. Wow, that's an incredibly high burden. And we're going to show you so much doubt in this case. So obviously, with the defense attorney, you have to stress that, which we did see Alan Jackson stress in his opening statements. Did you hear a word about reasonable doubt when Hank Brennan gave his opening statement? He didn't. And that's something that you have to do when you're the prosecutor or you're the plaintiff, whatever it is. You always have to talk about the burden of proof. And if you're the prosecutor, it just sounds something like this. Ladies and gentlemen, the burden of proof in this case, in a criminal case, is that you have to prove your case beyond a reasonable doubt. And we're very happy with that burden. That's a burden that should apply. And this is America. We don't want to send away people that are not really guilty. And we embrace that burden. We're completely fine with that burden. That's a burden that we're very happy living with. And at the end of this trial, you're going to see why all the evidence in this case proves beyond a reasonable doubt that you're not going to have any doubt in your mind that Karen Read is the one that committed this murder. That's what you have to do when you're the prosecution. You can't ignore it. So a number of problems that we saw with Hank Brennan's opening statements, and this is the way that you have to frame these issues. So the jury, number one, already is not going to trust as much Hank Brennan because he didn't tell them the full story. And number two, they already have these ideas in their minds about Google searches and about Michael Proctor, and that can already be changing the way that they think about this entire case. So I just wanted to point that out. It's a very educational. It's very important to see that this, I think, was a big blunder. I think it was a big mistake by Hank Brennan. And I don't know if he does this in all of his cases, but it's something that everybody out there should understand, that this is what you have to do during opening statements. You have to embrace your weaknesses. You have to explain to the jury why they're not weaknesses, why they don't ruin your case. You have to not mess up the timeline if the timeline is important in your case. You have to talk about the burden of proof, the reasonable doubt. These are just basic things that you have to do when you are opening a case. So I just wanted to point that out. I think it's something that it really bothered me when I saw Hank Brennan just completely ignore doing that. And it was just a problem in my mind. I mean, I think it's something that you all should see about. So this is going to be it for this video. And we're going to be continuing to follow the Karen Read case. Definitely subscribe, please, and like the video. And we will see you next time.